Hi guys, it's Kathy. I hope you're doing well. We made it to I have no idea. Monday morning, huh? Alright, new week. This is gonna be a great week. This is gonna be such a freaking good week. This is not gonna be a shitty week. Right? I don't know, Margaret. I don't know if you're still here, but it doesn't stop some other Australians from watching. Which I appreciate. I really do. Alright. Gee, what are we going to do today? Oh, I know. We're going to do part 2 of a lawyer getting in trouble. Josh, you missed yesterday. We were talking about sanctions. So, Josh, this lawyer asked for sanctions against another lawyer and a judge because of them putting forth motions to stop him from putting forth motions. He was denied. So then he went on to accuse the judge of appearing to be biased and racist and other things, and a couple other judges and police officers, but we were talking about sanctions yesterday. Okay, the video showed sanctions yesterday. Nobody was talking about it because I don't think they heard it. But that did happen. You can rewatch, you'll see. Here we go. This is where we stopped. They were taking a 10-minute break. Took like 30 minutes for this 10-minute break, but that's okay.
Let's give Lauren a few seconds. We are live.
Okay, thank you. Mr. Bell, we left off talking about Judge Anders and your motion to recuse. I believe you testified that you base your opinion on your interactions with Judge Judge Anders. Am I recalling your testimony correctly?
In part, yes.
Okay. Well, between June of 2018, when you were first admitted, and June 2020, when you filed your motion to recuse, how many interactions did you have with Judge Anders?
I think I had one.
You had one interaction?
Where I actually interacted with him. I think it was one. It was the, you had it as a, I don't know if you had it in your exhibit book. It was for the classic car. Classic car.
The classic car?
Yeah. You sent Mr. Duckett the docket. You sent him 2 dockets. One of them wasn't me at all. And the other.
Okay.
Oh.
I'm not talking about that.
All right.
How many interactions? Because that goes to 89-151, so I don't want you to prejudice yourself. Okay, so we're not talking about.
That wasn't me though.
Okay, well, we're not, okay, that's fine. So you had one interaction with Judge Anders between June of 2018 and June of 2020?
No, wait. Whenever the Jarvis case was, I don't remember the date. It was like 2017. So I had one interaction. It was a classic car case, and you sent the docket. That was it prior to these cases.
Okay, so the Myers and Miller cases are the only 2 cases that you had interactions, and not strike that. Between 2018 and 2018 and June 2020, how many in-person interactions did you have with Judge Anders?
Maybe one.
And when was that?
I think again, that's the classic car case.
Okay, since you keep bringing up the classic car case, What is the classic car case?
It was the case. I purchased the property and it had a classic car in it. The owner had died like 40 years ago, and I wanted to get the car in my name or sell it or repair it.
And this was after you were admitted?
No, I'm sorry. You're talking about after I was admitted. I'm sorry, you wasn't clear. I don't remember. It was around the time.
What I said was between June
Okay.
2018,
All right.
when you were admitted
All right.
into the practice of law,
Okay.
and June 2020, when you filed this motion to recuse. What personal interactions, in-person interactions, did you have with Judge Anders?
I never had a personal interaction. I had official interactions.
Where you saw him in court face to face, how many interactions?
Just a classic car. And I think that was, I'm sorry, I just want to clarify, I'm sorry, because I'm a little confused on it. It happened so long ago, but I do know.
It's very rude he doesn't say more about the car. Which car is it? Can you please say more? No.
I remember seeing him in court about that, and it was an uncontested motion. So that wasn't personal, it was official. And I don't recall, it was between like around 17 or 18. I don't remember.
And it was your motion,
Yes,
and it was uncontested.
correct.
So he found in your favor because it was uncontested.
Yeah, he had no choice, but yes.
Okay. So, you testified earlier that you believe that Judge Anders based his decision on retaliation. Are we talking about the Miller case? Or are we talking about the Myers case?
I don't know, you're directing it. What do you mean?
Well, it was your testimony. You said retaliation. So I'm asking you, in the Miller case, did you believe Judge Anders retaliated against your client?
Yes, absolutely. In both the Miller and Myers cases, I thought that. And they were put together for case management purpose, and they were put together even in the Commonwealth Court. So it was like one case with a bunch of plaintiffs.
And you believe it was based on race?
I believe it appeared. I think it objectively appeared that way.
Okay.
Especially when you know the identity of the clients and versus the defendants.
Okay. In your case memorandum that you filed, you didn't mention the race of your client, correct?
I don't think I did.
Okay. And you would agree that Judge Anders was not part of the settlement conference. I'm not the settlement conference, the case management conference.
He did not attend that. Eric Gorberg did.
And
Josh, I just threw a link in chat. So, we have this classic car museum right in the inner course, which is right down the road, that we can go to whenever we want. And oh my gosh, it's the best day.
based on your testimony, what evidence did you have at the time that you filed the motion to recuse that Judge Anders was aware of the race of Mr. Miller?
He knew my race, he knew me, and he knew Jarvis.
Well, I'm not talking about Mr. Jarvis.
Okay.
I'm talking about Mr. Miller.
So you're saying he knew the race of your client because he knew what your race was? Sir, that doesn't make sense.
So if you only had one interaction with Judge Anders,
Go ahead. No.
in-person interaction with Judge Anders, and you're saying that based on that interaction, he knew your race.
No, see, can I please answer your
Go ahead, please explain.
No. He knew who I was from the Jarvis Payton matter, from his case. Because that was that we had the hearing in 2017. And then, that between 17 and 18, and around the time that I got I got admitted by the bar, that's when the classic car issue came up, that real estate I purchased. So Anders knew who I was. He knew who I am.
Okay,
And he knows Payton. And Payton, after that case, after they vacated the conviction, Peyton got stopped and frisked, and he wanted me to do the case, and then we're in front of Anders. And it was the same time, I filed, as I said, I filed Miller and Myers. I filed them all together. So when I filed that motion.
So let me ask you a question, Mr. Bell.
Go ahead.
So it's safe to assume, in regards to Mr. Miller, that Judge Anders did not know the race of Mr. Miller.
I don't know what Judge Anders knew.
Thank you.
It's Judge Anders.
Now, Judge Anders denied your motion, correct, to recuse?
Yes.
Let's turn to strike that. Let's turn to ODC 31. Let me know when you're there.
I'm there.
Okay. Now, if you go through the pages on bait stamp 1500 to bait stamp 1518, these represent the email exchange between you and Mr. Hubbard?
It appeared to be.
Okay. Now, you earlier testified that Mr. Hubbard told Judge Anders and or Eric Orvik that this matter should be in arbitration, correct? Is that what you testified to?
Yes.
Okay. Can you turn to base stamp 1505? 15,505.
All right.
Okay. And this is a email from, it starts on 1504. And this is a email from Mr. Hubbard. And he says, I will not oppose you moving to have the Myers case in the major, this was dated, let's go back to the date, May 27th, 2021. So this was after Judge Anders' February 2020 order, correct?
Yes, it appears to be, yes.
And he says, I will not oppose you moving to have the Myers case in the major jury pool, either way, arbor jury trial, based on many years of defending police in these claims, including assault and battery. Your client's cases are not six-figure cases. Rather than go back and forth in this, just file your motions and we'll see how these cases end up. Is that an accurate reflection of what this email said from Mr. Hubbard?
That's what it says, yes.
So when you testified earlier that Mr. Hubbard directed Judge Anders to put this case in arbitration, you recall you saying that?
Did I use the word direct, or did I just say he told Judge Anders to put in arbitration?
Okay, well, he
Because I was
told,
at the case management conference. He told Eric Orber to tell Judge Anders he wants this matter in
Okay.
arbitration. That's what he said.
so this email reflects that Mr. Hubbard said, just file your motions. He doesn't care if it's arbitration jury trial.
Out of the other email, yeah, we had multiple email exchanges. There's more to this, but this was one of them. And this is a portion.
And then in 1507, Mr. Hubbard says, Aaron, I didn't say this was an arbitration case for any reason other than the value of the case is less than $50,000 for Mr. Miller to prevail. You see that?
Yes, I see that.
Okay. So, Mr. Hubbard did not oppose you file motions if you wanted this matter to go to jury, correct?
That's what it says.
Okay. And let's 1509. Is again an email from Mr. Hubbard. Hi, Aaron. Although I believe this case is an arbitration case due to the lack of evidence, and this was sent on May 27, 2021. He says, although I believe the case is an arbitration case due to the lack of evidence on damages, I won't oppose. Your client suffered no significant injury and he chose not to seek recovery of his gun and permit. I don't have a problem with making him whole in that regard, but I believe that Detective Coulter performed his job properly, and this is possibly a motions case. Now, after you received this email from Mr. Hubbard, did you file any motions?
I don't remember.
Okay. How about, go to 1512. In the top is an email from you to Mr. Hubbard. Thanks, but don't even waste your time. I killed myself before I did arbitration. A black jury will hear these cases. Do you see that?
Yes, I wrote that.
So you decided that you weren't going to do anything else in an attempt to get the cases into a jury trial, file
I did.
motions.
I did everything the law requires, and my
Okay.
clients did not want to go.
Now, getting back to, and I neglected to ask you this question. Getting back to the pre-conference memorandum, you testified that the case wasn't fully developed. And you said you were waiting for discovery or due discovery. Is it true that in regards to the plaintiff's case, you would had already had the information to put on the conference in regards to the plaintiff's injuries?
Ma'am, Ms. Emmons, at that point in time, the case had just started. That's what discovery is for. We don't develop it until we do depositions, interrogatories. So I just had what was in front of me, and I complied with Pennsylvania law under 1021 Rule C to request a jury based on what was told to me.
Well, Mr. Bell, I'm not talking about discovery in regards to the defense. I'm talking about discovery in regards to your client, evidence in regards to your client's injuries, to whether or not, they sought medical attention. Wouldn't you have already had that information?
Wait, what are you asking me? I'm sorry.
I'm asking about discovery in regards to your clients, that the information that you would have had.
You wouldn't have had that early in the case. How am I going to have medical records and all of that when I just get the case and I file a complaint in court to law? The discovery had not started yet. We had to develop the issue.
Okay, so your client, according to the complaint you filed,
Yeah.
your client was arrested in March of 2018.
That says it on there.
Okay, in 2018, your client was arrested. In February of 2020, which basically is almost 2 years, you didn't have the discovery in regards to your client's medical bills?
Wait, everybody did not have. In these cases, I don't think anybody was beat or anything like that, so it wouldn't even.
Everybody wasn't what?
Nobody was beat in this case, right? This ain't no excessive force. These are just regular run-of-the-mill assault and battery, malicious prosecution, or not even nobody's prosecuted. But there's just economic damages. There was non-economic damages. No loss of wages or nothing like that, so I wouldn't have that at this time, especially when these clients came to me. I filed at least one of these cases the day before the statute of limitations expired. They didn't come to me right after their case happened. They came to me within the limitations period. Both of them at the same time. It was weird, but I filed them on the same night. So it's what I had at that time, and then I was going to wait until the scheduling order was issued, and then we're just going to roll out discovery then.
Okay.
So yeah.
So you're saying that I'm not talking about Mr. Miller's case in particular. So you're saying that Mr. Miller came to you on the eve of the statute of limitations?
I know Myers did, and I filed them on the same day. So I don't recall the date, but I know it was some urgency because we were very close to the limitations period. It was we was pushing it, and that's when it came to me. So
there was this arbitration hearing they were talking about yesterday. He decided not to show up to, and he told his clients not to show up to. So the judge ruled in favor of the plaintiff. And then they were going to appeal it. Okay? I think he's going to use that example and a couple other examples like that of the judge being racist because the judge made decisions without having a hearing and seeing all the evidence. Well, they did have a hearing. You didn't show up. So that's what I think is going to happen. I don't know. We'll see what happens when his lawyer gets a chance.
Let me get these filed. I had these, okay, let me just file these. I interviewed the clients. They told me what happened. And I talked to them for a long time to see what type of case should we bring. And what I was told, yeah, this is definitely a jury trial all day.
So, did you think about following a precipice in order to toll the statute before you filed your complaint if it was on the eve of the statute expiring?
I didn't have to. The law doesn't say that. I did what the law requires. You file your complaint and you ask for in excess of $50,000, and I did that.
So you filed your complaint without doing any investigation?
That's not what I said.
I'm asking you a question. I didn't say that's what you said. I'm asking you a question.
I did the sufficient investigation that the law requires to file a complaint.
Okay. Let me see. 34. Now, ODC 32.
Speaking of Urban Dictionary, you can't give a thumbs up anymore. That's bad. I don't know why it's bad. Can't remember. Okay. In the 80s, when we wanted to say okay, someone couldn't hear us, when someone was giving us information, and we wanted to acknowledge that we heard them and we understood, and it was okay. It was okay. It's okay. Everything is okay. That's bad now. You can't do that. You cannot say okay anymore. It means something very, very different and offensive. Apparently now, I'm offending people. That's offensive now. I don't know why. I haven't looked up why yet, but I don't care. I'm going to say okay to whoever I want to, and I'm going to put my thumb up whenever I want to.
Now,
Take that.
you already testified that you did not appear for arbitration, correct?
That's accurate.
And that your clients did not appear. I'm sorry, Mr. Miller didn't appear for arbitration.
In none of these cases, no one appeared.
So, ODC 32 is the certificate of non-appearance of plaintiffs. You see that?
I see that.
Okay. And you also see there is no right to a trial de novo on appeal from a decision entered by a judge. Do you see that?
I see that.
Okay. And then after this certificate of non-appearance of plaintiffs was filed, you filed
Michael.
33,
Thank you.
ODC 33,
Appreciate it, Michael.
a petition for relief from judgment of non-process. Hereby, you filed the motion, and you see that.
Yeah, I see it.
And you filed the attachments to ODC 33.
Yes, I did.
And in that motion, you acknowledge that you and your client intentionally did not appear for the arbitration.
It wasn't a mistake. The clients made their choice.
I have just asked you admitted in the motion that you intentionally did not appear. Okay. I understand your position, Mr. Bell. Now, after you filed the motion, Judge Fleckman, the ODC 34 is your memorandum to the motion. You agree with that, right?
Hold on. Wait, you said my memorandum or the court's? I'm confused. You said that was ODC 34 was my memorandum?
I'm sorry, Judge Fleckman's.
Yeah.
I'm sorry, strike that. I'm getting confused now. This is Mr. Hubbard's response.
Which is it?
I'm sorry, I'm getting confused myself. This is ODC 34. This is defendant's motion, memorandum of law in opposition to plaintiff's petition for relief from judgment of non-process. I apologize. And you agree that is the defense memorandum?
It appears to be, yes.
Now after, and this motion, to your knowledge, was assigned to Judge Fleckman, Abby Fleckman?
It was assigned to a judge, and she ruled in favor of the city.
Okay, and Judge Fleckman denied your motion to overturn the non-pros, correct?
That's accurate.
Okay, now I'm looking for a book. And after that, you filed an appeal with the Commonwealth Court.
That's accurate.
You have 100 binders and you don't understand how they operate. What the heck? Someone help her. She gave up.
And for the record, ODC 35 is Judge Fleckman's order denying your motion. Is that correct?
Yep, that's accurate.
Now, ODC 36, is that the Commonwealth docket which indicated that you filed an appeal on behalf of your client?
Yes, it is. It appears to be so.
And it was filed on March 23rd, 2020? That's on 1631?
Wait, what was filed?
The appeal,
All right.
the notice of
All right, you said, I
appeal.
thought you were talking about the docket, all right.
No, the
Yeah,
notice.
it was filed timely. Everything was timely, yes.
And ODC 37. That's your 1925B statement, right? Your concise statement?
It appears to be.
And paragraph 3,
Yes.
this is the first time you mentioned.
See, right now she's just trying to introduce all these documents into evidence. And he's trying to explain whatever he thinks she might say later about why the document is an issue. That's why she's just asking a question about the document and he's going off on this other tangent.
Judge Andrews' brother's involvement in a police misconduct lawsuit that was pending at the time the arbitration order was entered. You see that?
I see that.
Okay. And you said that Judge Andrews was tainted by personal bias stemming from his brother's involvement.
No, I did not say Judge Andrews was tainted. I said it appeared based on what I discovered. I didn't say the judge was tainted. I don't know if he's tainted. I'm trying to be objective. That's why I say appeared.
Well, what evidence did you have at this time that it appeared that Judge Andrews was tainted by his brother's case?
I think I'm gonna explain that in the 3051 motion.
Well, I'm asking you to explain it now.
All right. Well, we have these cases. All right. So we have the history of me and Peyton, and we have these. We have the judge making rulings without having any evidence of what the value of the cases are. He said he makes subjective rulings, and I knew it was subjective because at the time he didn't conduct a hearing, he didn't issue a rule to show cause. And then I find out his brother is being sued for some type of racist stuff at the college in Millersville. And I informed my client what I discovered. They said add that in there, add that inside the 31.
I'm going to strike
I
what
worked
your
with
client
him at
said. That's hearsay, so I'm going to
15
object.
years.
But my question to you is,
Hold on, Ms. Ammons. Ms. Ammons. First of all, let's get the answer finished before
Okay.
you make a motion to strike. But you asked him why, And
Correct.
I think his answer is responsive
Okay.
to that. So let him explain why, and if part of the why is something his client told him, then I don't know what your basis would be to strike that, but let's deal with that after he finishes answering.
Well, where I left off. All right, so I told my clients, so I informed them what I discovered. They wanted to argue that in the motion, in the 3051 motion, to preserve the issue for appeal. They thought it was relevant. I thought it was relevant, just new information. I'm not saying I didn't say he was actually, I just said it appeared based on the information. They wanted me to file that, and we did. We didn't even argue that on the Commonwealth Court, though.
When did you find out about Judge Anders' brother?
I don't remember.
And how did you find out?
All right, so first I heard about something, but I thought it was just, I think it was from another lawyer. I never looked into it.
Who was the lawyer?
I don't remember. But it was on my radar, but I didn't bother to look into it until, just try to confirm. I wanted to be able to confirm. I don't want to just say stuff if I don't have a basis to do it. And I found the docket. I remember I found the docket, and I remember it was around the 3050 motion time to have it in, and I put it in there just to preserve the issue because it was an issue that I thought warranted further investigation, and maybe we could argue it to the Commonwealth Court. And I just had to preserve it in here.
Do you have personal knowledge in regards to Judge Anders' relationship with his brother?
Only he could know that. I mean, only he could know that.
So you don't know whether or not Judge Anders and his brother are close?
Brothers are usually very close. Very.
Okay. So your client told you, your client's not, your client's not an
And
attorney,
we're very
right?
close.
Mr. Miller.
I actually talked to all.
I'm strike that. Mr. Miller is not an attorney. Correct?
Yeah, we talking about the Miller case. Yeah, I talked to all of them together though. But last I checked, he's not.
Okay. So your client requested that you put it in there to preserve the issue.
Yeah, I told him what we could do on
Okay.
appeal and the steps to take. He thought, I agreed too.
So when you filed this on April 11th, 2022. You filed the 1925B statement, correct?
I don't remember the date.
Okay. And when you filed your motion to recuse in Judge Anders in June of 2020, you didn't have this information at that time in regards to Judge Anders' brother.
Yeah, I found out after.
Okay. And
But I knew his brother. I already knew about him.
how did you know about his brother?
Oh, I know everything. I don't mean to say it like that, but
Okay.
oh no. Yeah, I like to do research on things. And he's very public about it. He got pictures and everything with his whole family.
Okay.
So I wasn't, go ahead.
So when you filed your motion to recuse, you investigated Judge Anders and
No.
his family?
Okay, no, I don't care. No, come on now. With the Jarvis case, his family told me about Judge Anders. And they dealt with him throughout that criminal case, and that's why I agreed to come forward. But before I just came forward, I was the family told me about Judge Anders, and they said some things that I'm not going to repeat here. And that's how I found out about his brothers. And he got a picture, and it's like in the gay news or something.
Wait, who has his picture?
It's public.
Judge Anders put his brother's picture.
He got a whole articles in like the gay news of him and his family, how he grew up with lambs, and his dad was a stockbroker.
Okay.
And his brother was the police chief.
Okay.
Like that Jarvis Payton family told me that, and I didn't think it was relevant to why I should come forward and testify for him. So, yeah.
Okay. So, do you recall when Judge Anders, when the lawsuit in regards to Judge Anders, when was that filed? Do you recall?
Wait, what?
When was the lawsuit against Chief Anders
Okay.
When was that filed?
Ms. Sammons.
I was trying to make sure he understood me.
I know, but you misspoke when you
I
asked
did
the
misspeak.
question. And so you don't have to raise your voice and
Okay.
you just ask the question.
So, Mr. Bell, when did you find out, or when was Chief Anders' lawsuit filed? Do you recall that?
So when was it filed?
Mhm.
Those are two questions.
Well, since you used it in your concise statement, when was Chief Anders' lawsuit that you mentioned in your 1925 statement? When was that lawsuit against Chief Anders filed?
It should be in the opinion.
I'm asking
That's
you.
the best, I would think the documents speak for itself because I don't have an independent recollection. I know that case, and I was not involved in that case. I know it was pending at the time that this situation was transpiring.
Okay. Now, ODC 38 was Judge Fleckman's May 25th, 2022 opinion in regards to your appeal, correct?
This was her 1925 opinion.
Okay.
Yeah.
So you agree that that was Judge Fleckman's opinion? Okay.
Hold on. I guess if you say her name on it.
Okay. And ODC 39,
That lawsuit against Pete Anders was thrown out, by the way. Above reproach. I worked with him for 15 years.
you agree that that's the Commonwealth Court of Pennsylvania, and that's the opinion by Judge Wallace?
That's correct.
Okay. And do you see, on top of that, there were 3 judges involved in this? Judge Wallace wrote the opinion, correct?
It says it, yes.
Okay, and this matter was before 3 judges of the Commonwealth Court. Do you see that?
Yes.
Okay. Judge Wojcik, Judge Wallace, and Judge Ledbetter. So is it your understanding that all 3 judges had made a decision in regards to this opinion?
They made a wrong decision.
I'm not asking you that. Is it your understanding that all 3 judges took part in this opinion?
Yes.
And this, the Commonwealth Court affirmed the lower court, correct?
Yes, they did.
Now, did you appeal? Did you file allowance of appeal with the Supreme Court?
No, the chances of that is next to 0. It's like a 1% chance that they would actually grant it.
Now, once the appeal was affirmed by the Commonwealth Court,
That's my chances of meeting Thor, by the way.
wouldn't you agree, strike that, did you advise your clients that they had no avenue after that their case was, well, Mr. Miller's case was done?
Yeah, all of them. They all was aware. They know. They knew before it even got this far.
So you told them before it got to the appeal station, the appeals part, that their case was done?
Wait, what? Rewind it.
I asked you, once the Commonwealth Court affirmed the lower court, I asked you, did you advise your clients that Mr. Miller, that if you advised Mr. Miller that he had no other avenue to seek redress from the officers that he sued?
Yes, they knew. I told them everything. They already know, and I told them the appeals. Good luck with that. I mean, they knew what the law was. They knew from the beginning. I gave them all the advice they needed. They made a choice, and I think they made a good choice, actually. Yes, they was aware of that. If the Commonwealth Court says no, then the petition for allocated to the Supreme Court, you're gonna have like a 1% chance of them hearing the case. And I explained to my clients that the Supreme Court is not an error correcting court. They determine new issues. So this is, I told them.
So so Mr. Miller understood that he was not getting any money damages in regards to this case.
He understood that when Anders entered the arbitration ruling.
He understood that when Judge Anders entered the arbitration?
Well, I advised my client, I told him, he was aware that we were in treacherous territory, so to speak, or how could I say it? Because when Judge Anders entered that order without even a hearing or anything, my clients were very upset. Like they think this system is really bad. And I don't want to say what they said, but sheesh, they already figured that we didn't have no chances. We had no chance. Because he made a ruling on the case without having any evidence to do it. The clients were very discouraged.
Mr. Bell, to this day, do you understand that if you appeared at the arbitration with your client and that they had an adverse ruling, that you could have appealed that to the Court of Common Pleas?
The question is done?
It's done.
That's the way, but they didn't have a legal obligation to do so because arbitration forum did not have jurisdiction over the case.
That was your, what rule are you pointing to that arbitration had no jurisdiction?
Well, do you want to go over the?
No, I don't want to go, but
You asked me a question.
I did ask you a question.
Give it to you.
Hey, what rule was that, Mr.
First of all,
Bell?
the arbitration statute, right? We can go there. And then if you look at Rule 1021, and then I have cases that you objected to and that explain how this works. I'm not the only lawyer that didn't go to arbitration. I'm the only lawyer at a disciplinary proceeding for it. And Hall versus Reeve and the cases with Judge Wallace, man, we can talk about that, but I don't know if it's appropriate now because I'm going to present it in my case. I did not just, you don't have to go to arbitration. That's crazy. Who in their right mind would do that? My clients did not want to go to the arbitration forum and ask for more money than what it could legally give. They thought it was retarded. Okay, they thought it was dumb as hell. That's what they said. They said, this is retarded. And then I explained to them the backdrop between Jarvis Payton, my case, that news article that's driving, that caused all of this nonsense. They were fully aware. And we're going to talk about the arbitration statute. Again, I'm sorry, I'm not trying to get on nobody's nerve. I'm going to shut up. Actually, next question.
Okay, so would you agree that your clients were prejudiced by your actions?
No, absolutely
Okay.
not. They were prejudiced by Judge Anders' actions and Judge Wallace, and I can prove that.
Okay. Well, I look forward to that. Let's go to ODC 40. Let's talk about the Myers case. And I'm not going to go over all the questions that I asked because it pertains to the Myers case as well.
If I just may, Mr. Lindau, Attorney Randall Amos, I don't want to hold you to this, but it's 12:30 approximately.
Oh.
Do you think you have like another hour, half hour?
You want to take lunch
Probably
now?
not.
Yes.
I will. It seems like you're transitioning to a new subject matter, so I will defer to the panel. But if it's going to be a while, I suggest that we take lunch.
Right. Let's do that.
Okay.
So 30 minutes, okay? Need longer, anyone?
30 minutes works. 30
Okay.
minutes
30
works.
minutes.
Thank you.
30
Thank you.
minutes.
30
and,
minutes works.
Mr.
You
Bell,
can stop
were-
the live stream.
We are
Sound.
Yes.
Go ahead.
Okay. Okay, Mr. Bell, now I want to turn our attention to Myers, which is ODC 40,
I'm there.
the docket. Now, you filed this case in October 27, 2019?
Yes, that's what it said.
Okay. And so that's ODC 40. ODC 41 is the actual complaint that you filed?
Yes.
Correct?
Correct.
Now, ODC 42 I'm gonna ask you the same questions I asked in the prior case about the case management conference notification. Did you specify that you received both of these at the same time? They were combined, the Myers and the Miller?
Yeah, I've received just the same time.
Okay. And you were required to file a case management conference memorandum, correct? As with the other case.
Yeah, case management memorandums should have been filed.
And according to the rules, what you say you followed the rules, this case management memorandum was required to be filed 5 days before the conference, correct?
Whatever the rule says.
Whatever the rule said? Okay. Now, the conference was held on February 6, 2020. Do you recall that?
I remember the conference, I don't remember the specific date.
Okay. And would you agree that you filed the conference memorandum in the Myers case the same time you filed the Miller case?
Probably.
On February 6, 2020 at 2:03 p.m.?
If it says that, yeah.
Okay. Now, going through this case memorandum in regards to Ms. Myers and Mr. Jarvis, you indicated that the type of permanent injury was psychological trauma. Would you agree that's what you listed?
I don't have it in front of me, so.
Okay, would you like to see it?
If it's in there, I guess, yeah, I don't know all the details about it. I know they only sought psychological, damages with psychological injury.
Okay. And would you agree, because I believe I gave your counsel this the last time we were here, when we were before Judge Anders, I gave your counsel a copy of this. Would you agree that where it asks, is there any permanent injury claim, you did not check a box, but you did indicate psychological trauma?
If it says that, yes.
And you would agree that the dates of medical treatment, you put NA?
If it says that,
Is medical treatment continuing? You did not check a box, yes or no?
yeah, if they wasn't, yes, correct, yeah, there wasn't any medical treatment at the time, to the best of my recollection.
Question 6, has there been an inpatient hospitalization? You checked no?
Correct, because he wasn't there.
Has there been any surgery? And you did not check any box, yes or no? You agree with that?
That I didn't check the box, if it says it, if the box is blank, then I didn't check it. Because I don't have it in front of me, that's why I like.
Would you like a copy? Mr. Duffy, do you have the copy I gave to you? The last hearing?
Is this going to be offered into evidence?
Yeah, no, this is not. That's why I'm asking questions. This is not, because I obtained this after our deadline to exchange exhibits. So that's why I'm asking him questions on the record.
Well,
I mean, if I can offer it into evidence.
I don't
if they
hear an
won't-
objection, so. Make sure Mr. Duckett has a copy of whatever.
Mr. Duffy received a copy. You have a copy, correct?
I do have a copy.
He has a copy. I gave it to him the last hearing.
Okay. I'm not sure how the committee is supposed to include a document in our report that isn't going to be offered into evidence.
Well, it's going to be via the testimony.
Okay.
That's why I have to go through it all, so it can be in the testimony. If Mr.
Sir, he just told you to object. He clearly just told you to object. All you have to do is object. Nope, we're going to have to sit there and more of these questions.
Duckett will agree that I can offer this into evidence,
I don't agree.
then it has to be read in then. Okay, I think the last thing I asked was, has there been any surgeries, and you didn't check a box. You agreed to that?
I don't want to object to the continued questions about a document that my client doesn't have in front of him.
Fine.
Can you give it to him, please? I gave you a copy.
I need to
Well,
find
Ms.
out.
Salmons, if you want to make copies of a document to show that, then you can do that, but Mr. Duckett's entitled to look on at the document while you're in.
Let me see if I have an extra copy, because I did. Lo and behold, I have an extra copy. There you go, Mr. Bell.
Thank you.
I would like to get into an argument with her.
You had the Myers Case Management Conference memorandum that you submitted, correct?
Yes.
Okay, let's proceed. Where it says number 8, approximate medical bills to date, you put N question mark A, you see that?
Yeah, I see that.
I think it was supposed to be a slash. Okay.
Oh, yeah, that's, yeah.
Approximate medical bills recoverable in this case, you put NA.
Yeah, I didn't know. At that time.
Are there any existing liens, workers' compensation, DPW, medical, etc.? You did not check a box, correct?
That's not, yeah, I didn't check. It wasn't necessary.
Number 10, time lost from work, you put NA, correct?
That's correct.
Number 12, is there a claim for future lost earning capacity? You did not check a box.
That's, yeah, I didn't check a box. I probably didn't know how to answer that.
13, are there any related cases or claims pending? You did not check a box.
That's accurate.
Number 14, do you anticipate joining additional parties? You did not check a box.
That's correct.
Okay. Number 15, it says plaintiff's factual position as to liability. You put defendants stopped plaintiff's vehicle without cause, and when Plaintiff Myers attempted to provide her insurance and registration information, defendant Romito saw Plaintiff Myers' lawful firearm in her glove compartment. Defendant Romito then began panicking and pointed his Glock pistol at Plaintiff Myers' head, and then proceeded to arrest her for unlawful gun possession, even though plaintiff has a valid license to carry and did nothing to alarm defendant. Defendant Molowski followed Romito's lead and pointed her Glock pistol
The courthouses in Philly aren't great.
at plaintiff Payton, took him into custody and informed him that he was being arrested for unlawful gun possession, even though defendant knew that he never possessed Plaintiff Myers' firearm. Plaintiffs were detained for approximately 30 to 45 minutes prior to being released. Would you agree that's what you put on this document?
That's a summary. That's not all the facts, but yes, it's a summary.
Number 19, the demand, you put in excess of $50,000. You
Yeah.
agree that's what you put?
Yes, that's appropriate.
Okay.
Yes.
And you agree that this document that you filed on February 6th at 2:03 p.m. is a document that Judge Anders testified to that he used to make his determination about the arbitration limit.
If this is the same document, I mean, I don't know for certain, 'cause I just physically got it. I haven't seen it before, but he testified that he made his decision not on the complaint, but based on the case management memo. So I'm assuming it must be this one. So the answer would be yes, to the extent that I can answer that, because I don't have this. I just got this now from you.
Okay. When Judge Anders testified, do you recall me handing a copy of this to your counsel?
Ms. Hammond, because it wasn't an exhibit, it wasn't part of the hearing committee, the record is not gonna be clear on what document you gave Judge Anders, and I don't see how.
Well, Judge Anders testified to it. He did testify to it.
That the document wasn't identified and it wasn't admitted. And I'm just saying that based on the record as is now, it's gonna have to be something that we consider whether we can even rely on a document that.
Well, may I establish foundation then? Is this the document that you filed?
mean, I don't really know. I would have to confirm. I would like to think you would tell the truth and wouldn't make one a document. So,
Okay, Mr. Bell. ODC 42? Is that the case management order expedited track that you received after your conference?
it appears to be, yes.
ODC 43?
I'm at 43.
Before we go to ODC 43, did Judge Anders, based on the docket in 40, you can look at the docket if you want, did Judge Anders enter an order transferring this to arbitration on February 6th? Do you recall that?
So, what order you talking about? I'm sorry. So, it was the, after the case management conference, there was orders like issued immediately, scheduling jury trial. And then after, there was another order saying we can't have a trial, we had to arbitrate the case.
February, ODC 40, base stamp 1668. February 27th, 2020, I'm sorry, February 26th, 2020, did Judge Anders enter an order transferring this mandatory arbitration, to arbitration, isn't that correct?
Hold on 1 second, wait.
It's on the docket.
Yeah, but it's, no. Yes, yeah, I see it right there. It's in the middle.
Now, after that was entered by Judge Anders, you filed a motion, which is ODC 43, to have the matter transferred to remove controversy from mandatory arbitration. You recall that?
Yeah, I filed 2 motions. Yeah, but yeah, I did.
I'm talking about in the Kim Myers case. I'm not talking about the other case.
I did everything together. That's what I'm saying. That. But yes.
Now, your motion was denied, correct?
Was it? Yeah, right. Yeah, I know one of them was denied. Yeah, the Myers was.
Okay. Now, after it was denied, you filed a motion to accuse Judge Anders in this matter, and that's ODC 44.
I filed the motion to recuse, yes.
And in this motion to recuse, you again talk about how Judge Anders was biased against you
So
and your clients.
I'm sorry. Yeah, I didn't. I say it appeared. I'm not saying he was. I said it appeared based on the information that I had.
And you also stated that the sole basis for Judge Anders' orders is the Philadelphia Police Department's defendant's personal preference for arbitration. You put that in your motion as well,
That's
correct?
actually true. Yes.
Okay. Now, you also said that Judge Anders, this is number 7 on 1724, where you said that Judge Anders' arbitration orders in Miller and Myers has the appearance of being based entirely upon a subjective belief that a black patient's pain and suffering is not worth a jury's attention. In addition to appearing as a clear signal that he will disregard a plaintiff's basic rights to appease the Philadelphia Police Department and Philadelphia Solicitor's Office. Correct? You put that in there?
Yes.
And what evidence did you have to include that?
And the evidence I had is conduct. I was just judging his conduct in addition to, again, what I know about Philadelphia Court of Common Pleas, and especially the Jarvis Payton matter. And we on Miller and Myers, yeah, Jarvis Payton, yeah. And my clients, they wanted me to file this motion, especially Mr. Payton. because he personally dealt with Anders before. So you got to look at like what I had here was what was in front of me.
Now, let me ask you a question. The Jarvis Payton matter, he was convicted sometime in 2015, 2016? Is that accurate? Something like that?
Something like that.
And this happened in 2020.
Wait, what? Wait.
Your motion to recuse.
Yeah, but the case, so we didn't have the evidentiary hearing when he got reversed until like 2017 because he delayed the case by like 2 years. He didn't want to hold a hearing.
So the complaint, I'm strike that the case that was filed by Ms. Myers and Ms. Jarvis occurred at least 2 years, 3 years after Mr. Jarvis was convicted of a crime, correct?
No.
Okay.
We got the procedure, we got the facts a little mixed up. He got convicted of, well, technically he was convicted. And that case with the officer happened in around 2015, I guess. I don't know. I wasn't involved in this criminal case. I don't know. So know what I know when I got involved to testify. But the appeal courts made this decision in 2015, but we didn't have a hearing until like 2017. Yep.
But Judge Anders didn't preside over it. He presided over the evidentiary hearing.
He presided over the whole case. He the one that found Jarvis guilty. That's why Jarvis was saying how racist he was and how he treated him so bad throughout the whole case. So when I'm filing this motion, my clients are especially informed. And Jarvis has the personal, he thinks Anders is very unfair. So he's a part of this too.
I understand what your clients are saying, but as an officer of the court, what investigation besides your client's opinion did you conduct to determine that Judge Anders in this matter was racially biased, appeared, quote unquote, racially biased? What independent investigation did you conduct as an attorney, as an officer of the court?
Can I answer it now? Yeah, so well, first, I had his conduct in front of me. Mr. Hubbard was telling me at the case management conference that my clients...
Wait.
No. Ms. Ammons, no. You asked a question about what basis he had to make the statements. You can't cut him off when he's answering your question.
So this motion was based upon, and I was trying to be as objective as possible, because I understand it, we cannot be subjective, especially when you're dealing with judges. So I looked at what I had in front of me, right? And I had I lived a prior experience with Anders. And he was upset with me at that hearing, which we'll talk about. I knew what happened there. I knew that he did not follow the law and disregarded Jarvis's rights and said he couldn't have me testify or couldn't get into trial. The cops in all our case, everybody was white. And I'm not saying every white person is not even going there. It's just what I had in front of me. He judged the value of 3 people's cases and he did not even ask me, like, how did I feel about it? He made a whole decision on the client's case. And the arbitration the plain language of the statute and the rules that we've been talking about, we're going to talk about later, says you cannot do that. And there's case law on it. And I had this at the time. So I understand what the arbitration statute says. And I understand how it's interpreted. In courts, they automatically every time throw everybody case. If you don't go to arbitration, they throw your case out. Every court, I swear to God, that I'm aware of, that's public. Every time it gets slapped back. They all say it's jurisdictional. You can't do that. And I have this in front of me at the time I'm filing this motion. And I'm talking to the clients, and I ask them, what do you think we should do? Because if you file a motion to recuse, that's really going to piss the judge off. We all know that. You don't follow me. Just deal with your lumps. They said no. Absolutely not. They're treating us different because we're black. And knowing the reputation of the Philadelphia Court of Common Pleas, as I do, and a bunch of scandals, I say, look, let me be careful in this. I'm not saying he's actually biased. It appears that way. Okay, it appears. Or Hubbard at the case management conference, Mr. Hubbard said my client's case was not worth anything. And he said, I've been doing this for 30 years. Yeah, you should just take $2,000. And he was insulting me and my clients. And Mr. Hubbard, I dealt with him last time on a prior case where he told me so everything I had at the time I thought this motion was appropriate. That was my investigation.
Did Judge Myers, I understand about Mr. Jarvis, did Judge Myers know that Miss Myers was black?
Judge Anders.
Judge, what did I say? I'm getting confused. Did Judge Anders know that Miss Myers was black?
I'm not Judge Anders. I mean, I don't know what is going on in his mind.
But you said that,
Objection to cause of speculation.
Yeah, I mean, Sam, I think you asked Judge Anders that question.
yeah,
So you don't need to ask Mr. Bell that question.
okay. Mr. Bell, now, arbitration was scheduled in this matter, correct?
That's accurate.
And you received notice of the arbitration date?
Absolutely, I did.
And you intentionally decided that you nor your clients were going to appear at arbitration?
My clients determined for me. And I thought that was a good decision.
And was that based on the advice you gave them?
It was based on their reading of the law, my reading of the law, and Pennsylvania clearly established law concerning when lawyers don't go to arbitration.
Okay. So after you failed to appear at the arbitration, the case, Miss Myers and Mr. Jarvis's case was non-pros, correct?
That's accurate.
And you filed a motion for relief. Let me backtrack. ODC 45, is that the certification that you did not appear?
Yeah, it appears to be.
Okay. And 46 is the motion or petition for relief from judgment of non-pros that you filed on behalf of your clients?
It appears to be.
That was ODC 46 for the record. ODC 47, is that the order entered by Judge Fleckman in regards to your motion for relief? That's ODC 47?
Yeah, I guess it is, yeah, it appears to be.
And it says the motion is denied as moot because a judgment of non-pros has been entered. Even if that judgment had not been entered, the court cannot overturn a determination made by another judge of this court in this case. You see that?
I see that.
So after Judge Fleckman denied your motion for relief, you filed an appeal on this matter, correct?
Yes, it did.
And that's ODC 48? That's okay, sure.
Oh, here we go.
Just give us a
Well,
moment.
Granny, we got a long way to go.
Okay, go ahead.
Okay, you filed a notice of appeal in March of 2022?
If it says that on here,
1813.
yeah, I filed an appeal, went through the whole process, so yes.
And you were ordered by Judge Fleckman to file a 1925B motion.
Charcoal chicken is probably chicken barbecue, not barbecue sauce. That's not what I mean. Chicken barbecue, where we barbecue it, on the barbecue, with charcoal.
Statement of matters complained of on appeal, and that's,
Or gas or propane.
is that ODC 49? Is that what you filed?
Yeah, it appears to be, yes.
And again, you stated, and I'm going to point you to number 3,
I'm there.
where you said that it was unfairly placed into arbitration. And that their rights, your client's rights were, their rights to a jury trial by jurors whose impartiality appears to have been tainted by personal bias stemming from his brother's involvement in the police misconduct lawsuit that was pending at the time the arbitration order was entered. You see that?
Yeah, I see it.
Okay, you still stand by that statement?
Yes,
Okay. So pending at the time the arbitration order was entered. So the arbitration order was entered in February 2020, correct?
I guess it was, yeah. I don't remember the dates, but it was entered. I remember it was entered.
Was Judge, to your knowledge, was Judge Anders' involvement in police misconduct lawsuit, was that filed in
I don't
February 2020?
I don't have a recollection of that. I just know I had the case.
Now, ODC 50 is Judge Fleckman's opinion. You agree with that? That was filed in this case?
Do I agree with the opinion or I agree that?
No, was it that this is the opinion that was filed by Judge Fleckman in regards to your appeal?
It appears.
Now, ODC 51. This is the opinion that was entered on April 18th, 2023. The memorandum opinion was by Judge Wallace. Do you see that?
Yes, I see that.
And again, with the prior case, the Miller case, it was before 3 judges of the Commonwealth
The
Court.
same panel. They were determined at the same time.
You see the
That's how I always thought I would meet my next husband. We would both be reaching for the same rotisserie chicken at the same time at the grocery store.
3 you see the 3 judges, correct?
Yeah, they were at the front.
And the 3 judges affirmed the lower court, correct?
Yes, that's accurate.
I don't think we discussed this, for identification purposes. ODC 52 is the DD7 that was sent to you in regards to the Myers case, correct?
Yeah, written by Judge Wallace, yeah.
No. ODC 52, for identification purposes, because I don't think I asked you about this in the cross-examination in regards to the Myers. We went right to your answer to the DB7. I'm saying for identification purposes, ODC 52, is this the DB7 that you received in regards to the Myers matter?
Yeah, it appears to be.
Okay. We already identified
Sorry,
Wait.
You said that 52,
$7.99.
Myers Center?
it concerns the Myers matters.
Are you sure about that?
This is Judge Fabrino.
Yeah, this is.
You said Myers.
Murphy. I'm sorry, Murphy matter. I have my M's messed up.
You might want to ask the question again.
Too many M's. ODC 52, which was sent on September 20th, 2023, which is the DB7 request for statement of the respondent's position. Do you remember getting this? Is this the DB7 that you received in regards to the Brianna Murphy versus John Doe Police Detective #1? Do you recall this is the DB7 that was sent to you in regards to that matter?
The Murphy matter, it appears to be, yes. Okay.
ODC 53, you already identified as your answer to that DB7. ODC 54 is dated April 3rd, 2024, which is regarding the complaint of the Honorable Stacey S. Wallace. Do you recall that this is the DB7 that was sent to you in regards to the Miller and Myers matter?
It appears to be.
Okay. Now, we're going to go to ODC 55. We start with base stamp start at 1886.
I'm there.
Is this your response to the DB7 letter that was sent on April 3rd, 2024, in regards to the Wallace complaint?
It appears to be, yes.
Now, in your answer to the DB7, which it starts on 1886, you said that Wallace's opinions in Myers and Miller are unconscionable and wrong. The decisions are so blatantly biased and legally untenable that she had to disregard the law to justify them. Are you saying that Judge Wallace was blatantly biased when she considered this?
I could prove it.
Okay. Do you know Judge Wallace?
Wait till we talk about her opinion.
Do you know Judge Wallace?
I know she made a horrible ruling here. I don't personally know her.
I'm not asking about her rulings. I'm just asking, do you personally know her?
Okay, all right. Mr. Bell, question was just, do you know Judge Wallace?
The answer is no.
Besides this case, because you appeared before that three member panel and you argued this case, correct?
Correct, and I remember.
Okay. Yep. Is this the only case that you appear before Judge Wallace in the Commonwealth Court?
Yes.
You also say that Judge Wallace's complaint, the complaint she filed with this office, is a complete waste of everyone's time because it points to no plausible ethical violations. You still believe that?
Absolutely.
Now, also in your answer to the DB7, I'm turn to page 1889. 8
I'm there.
Okay. Now, you pose a series of questions in your DB7 answer, starting with especially disturbing is Wallace's complaint that respondent said that a black jury is going to decide this case. You see that?
I see that.
And then you ask, what is wrong with black people serving as jurors in a city where more than half the population is black? Did Judge Wallace, in her opinion, state that black people serving as jurors in a city where more than half of the population is black, did she state that it was wrong?
What? I'm sorry.
Did Judge Wallace, in her opinion, state that it was wrong for black people serving as jurors in a city where more than half the population is black?
I object to how the question is characterized. She just asked about Judge Wallace's complaint, and now she's asking about Judge Wallace's opinion.
I'm asking questions about what Mr. Bell put in his answer to the DB7. That's what I'm asking.
Ms. Hammond, I think your questions could be a little bit clearer about what you're asking.
My question to you, Mr. Bell, is, in your response to the DB7, you state, especially disturbing is Wallace's complaint that respondent said that a black jury is going to decide this case. You see that in your response?
Yeah, and I remember
Okay.
the email. I remember, yes.
Then you ask, what is wrong with black people serving as jurors in a city where more than half the population is black?
Correct.
You posed that question.
Yes, I did.
I'm asking you, is there anywhere in Judge Wallace's opinion that she said it's wrong that with black people serving as jurors in a city where more than half of the population is black? Did Judge Wallace, in her opinion, say it was wrong?
This wasn't appropriate for opinion, no.
It's not appropriate for what?
For her opinion. She wrote a complaint on me about that statement. So it wasn't in her opinion, if that's what you're asking me.
Do you know for a fact that Judge Wallace put this in her complaint to this office?
How am I, may I answer the question? So you say that in your DB7, it says Judge Wallace wrote this complaint or made this complaint. So you don't say that nobody told me that she didn't write the complaint. So all I have in front of me is, oh, Judge Wallace wrote a complaint about me. So, and then when I read it, I was like, why is she complaining about me telling Mr. Hubbard in a private email that black people are going to serve in the jury? I don't understand, why would a judge write that? That made me alarmed, very alarmed.
Mm-hmm. So based on the DB7 you got, you believe Judge Wallace made those statements?
No one told me otherwise,
Okay.
so yes.
Now, you also said on the same page, 1889, Wallace's conduct in this matter, are you talking about the Myers and Miller's matter?
Wait, I don't know where you are.
I'm talking right above, especially disturbing. It says Wallace conduct. It's right after
Oh, I see it.
Wallace conduct in this matter appears motivated by a deep-seated personal bias and highlights a shocking level of ignorance and disregard of the law.
Yep.
Are you talking about, what matter are you talking about? Are you talking about the matters that she adjudicated? Or are you talking about the complaint that she filed?
All of it. Yeah, her ruling in this, when I get this complaint, yes.
So you believe it was motivated by a deep-seated personal bias against whom?
Clearly me, because this is directed towards me.
Okay, but you don't personally know Judge Wallace?
I personally know what she did in this case.
Okay. Um, 1890. You said that and this is a question you posed in your response to the complaint, is Wallace's frivolous complaint in the form, strike that, is Wallace's frivolous complaint a form of a high-tech lynching that Justice Clarence Thomas observed Black Americans experience whenever they dare to think for themselves or disagree with a white person? Do you still agree with that statement?
Yes, especially now.
Okay.
Look, if he can prove what he's saying, it's a big deal. It will be a big deal. We don't know yet. They're still deciding. Supreme Court has to pass down a decision. You know, they don't go quickly.
So, you believe, let's straight that. So ODC 56. That's a petition for discipline that was served to you in this matter, correct?
I mean, yeah, I guess it is. Yeah, it looks like it, yes.
And then ODC 57 is your answer to the petition for discipline.
It appears to be.
Okay, and you signed off. You signed the verification,
Yes.
and in your answers to the DB7s, you also signed verification, correct?
I signed the what? I didn't hear that.
Verifications.
Yes.
So you signed a verification. That's the wrong one. In the DB7 that was sent, ODC 55. On 1894, I, Aaron Bell, swear and affirm under the penalties of unsworn falsification to authorities that my above answers are true.
You just slow down a little bit.
I'm sorry.
Thank you.
I'm sorry, Ken. Do you see 1894?
That's my verification.
That's your verification. Okay, I'm not gonna read it because we all have the documents. And also, can you go to ODC, because I forgot to ask you this. ODC 53, base stamp 1871.
The Supreme Court will either dismiss the case publicly or privately. I lost the word. Not condemn. censor him, or he'll get suspended, or he'll get disbarred. Those are the only options, the outcome of this.
That's your verification as well, correct?
1 second. Yeah, 71, yes.
So after Judge Rubino, I'm going back to Rubino, when he made his decision, you raised his racial bias, correct? In the DB7 answer?
So when you say I raised it, I did not, what do you mean by that?
You made a statement in your answer to the DB7.
Correct, yes.
Okay.
Based on, yes.
And then, as we reiterated, when Judge Anders ruled against you and your clients, you made allegations of an appearance of racial bias against him, correct?
Yes.
Okay. And when Judge Wallace and her panel of 3 judges made their decision to affirm both the Miller case and the Myers case, in your response to our office's DB7, you again state that she had a racial bias.
She wrote it in a complaint.
Okay? I have no further questions.
Any questions at this time?
None of this. Well, I'll have the chance to bring it back.
I understand you're gonna call him as a witness in your case, but you're entitled to ask questions now if you like.
I do have a few questions.
He's a civil rights attorney, so that's all he does all day.
Let's start with the last thing you just said. When you talked about racial bias, when Ms. Amos said you accused Judge Rubino and Judge Anders of the appearance of having racial bias, you said that was tied to their conduct in the court, correct?
That's accurate.
I'm gonna object because that was not his, he was talking about the court of common pleas. He didn't say federal court.
Okay, Sammons, so
So I object.
argue about the questions. What's the objection?
Object because that wasn't his, he's mischaracterizing his testimony.
Well, you can ask him some more questions on recross.
Okay.
You were just asked about Judge Rubino's ruling that whether or not they gave the appearance of racial bias. That was tied to his judicial conduct, correct?
It's Judge Rubino, not Rubino. I'm sorry, I'm not trying to, Yeah, based on the way I was treated by him. And the comment he made about blame yourself, that was just really, the blame yourself comment, that caused me this, and then how he treated me, and how he just rubber stamped, he gave the city substantial deference when it wasn't warranted, and it just appeared as though, to me, that I was being treated differently.
My daughter has a life-size cardboard cutout of Tom Holland, and she's had it for years. And it's the worst thing in our house. Scares the shit out of me constantly.
And then when Judge Anders, when Ms. Anders said you gave his rulings gave the appearance of racial bias, that again was in regard to the.
I'm gonna object to the leading questions. If he has
Let's hear the rest of the question. Don't answer it yet, then we'll hear the objection.
Right. That again, what was that? When you said they gave the appearance of racial bias, that was tied to what conduct?
Okay.
Wait a minute.
Go ahead and answer.
I don't know what he's talking about. I'm sorry.
Again, you were just asked about judicial rulings and whether or not they gave the appearance of racial bias. I'm asking, with Judge Anders, the appearance of racial bias that you alleged in your motion of accuse came from his judicial conduct.
Then now I'm gonna object because that's leading.
That is leading, Mr. Duckett. See if you can ask it in the way this is.
That appearance of racial bias was tied To what conduct?
How the court automatically and subjectively just took the law department's say so that my client's cases weren't worth anything, essentially, without a hearing or any evidence, and in violation of the plain language of the statutes and even a rule that he cited. He cited Rule 1021D, but he didn't comply with that. It's an objective standard. You can't do anything subjectively as a judge. Even as lawyers, we have to have a subjective or an objective basis for our conduct. And knowing that, again, as I said, knowing the history and the reputation of the Philadelphia Court of Common Pleas, which I'm very familiar with, and then the prior incidents with Peyton and Jarvis, it appeared that like he was just ruling in favor of the city, and I'm the only black lawyer involved. All of my clients are black, and the police officers who were sued, they were all white. And knowing what I know about the court, Philadelphia Court of Common Pleas, and that's not every judge, to be clear. I'm not saying every judge, but it has a notorious reputation for, disparatory or discriminating treatment. And especially his rulings that without a hearing, without any evidence, he didn't even show cause to see why the cases should have a jury trial. And when there's no basis for his ruling, what else could it be? And I know Judge Anders know my race. He's seen what I look like, because we had more than one hearing on that incident with Jarvis Payton. He knows Jarvis Payton. He might have said he didn't, but he does. You know what he looked like. So based on that, and knowing the history of the courts, and I did not say he was actually biased. I said it just gives off that appearance.
So we talked about Judge Rubino and Judge Anders' appearance of bias. Does
I never
Judge
watched
Wallace's
it.
appearance of bias, is it different?
I might have watched 2 total episodes by accident.
Yeah, so I said that because
No.
I get a
Josh.
complaint from an
I tried.
appellate court, and a basis for me to be disciplined is because I told Mr. Hubbard in a private email, and me and Mr. Hubbard go back and forth. Our history started with the case in the federal case I had. He wasn't assigned to that case, but he was a part of it. So I guess we just had a reunion or whatever. But when I get this DB7 from ODC, but it's saying it was written by a Judge Wallace, and she complaining that I said black people are going to serve on a jury. I mean, to me, yeah, that seems very biased to me, exceptionally biased.
Now,
So that's why I responded like that.
when you said that, and you just mentioned her complaint, was it tied to the complaint or to her rulings?
It was kind of both. So I thought all right. I seen her ruling in the case. She made a ruling that we strongly disagree with. And it's based on her ruling, especially how she cited Hall versus Reeves. That decision is based on a deliberate misinterpretation of the law and a selective quote that caused me extreme alarm. So between that complaint I got from her, where she's complaining in part that I said black people won't serve on a jury, and then her reliance on Hall versus Reed and how she misquoted that case to support the decision, that caused me to think, okay, I see what's going on. Y'all don't want black lawyers bringing civil rights cases. That's how it appeared to me. And yeah, that's just how it appeared to me. I'm the only one being treated like this. So that's why I responded like that in the DB7.
Okay, now it gets hard because he's talking about her opinion on this case that she ruled on, and he didn't like the way she ruled on it. Okay? They just had, before this, I cut it all out. It was boring except for that one little part I left in. They just had a long motions hearing before this trial started about this case. All right? They are allowed to bring Judge Wallace in to question her, and they're going to. but they are not allowed to ask any questions about how she came up with her ruling and her opinions on that ruling. So he's talking about, I did this because of what she said in her ruling. They are not allowed to bring that up. They're not allowed to talk about it. They're not allowed to question the judge about it. So that'll get kind of difficult for them.
You were asked about knowing when this case, the Myers, the Miller cases, you were asked, did you know when they were sent to arbitration? And I'm asking you, prior to them being sent to arbitration with Judge Anders, how are the cases listed? So subsequent to case management conference, where were the cases, how were the cases initially listed or scheduled right after the case management conference?
Jury trials, both of them.
And that was done after the case management conference?
Yes.
Right. And after that, that's when the judge.
Objection leading.
We haven't heard the question yet.
After that case management conference and after the cases were listed for trial, is it your understanding that the judge himself put those cases in arbitration?
Hold on a second.
Objection leading.
It is leading, Mr. Duckett. Can you rephrase it?
Sure. After the cases were listed for jury, after the case management conference, how did they get listed for arbitration?
Judge Anders issued an order where he said he determined the value of the case is it's less than $50,000 on 3 people's cases.
So, with regard to, you heard Judge Anders' testimony. When Judge Anders said that he relied on the evidence that he relied on, the information that he relied on to put the cases in arbitration, do you believe that he examined all the court documents and all the evidence related to this case?
Objection leading.
From my recollection of Judge Anders' testimony, he did not review what he was supposed to review, which is the complaint. The complaint governs everything, and the complaint is the instrument that sets forth everything for the judge to move on the case. He looked at a case management conference. That's not binding on anything. And he said he made a subjective ruling. He said that like 3 times.
The case management conference they had went over that checklist that she went through question by question because he didn't bother answering a lot of the questions. In his defense, they asked for that to be filled out way at the beginning of the case. So he didn't know the answer to a lot of them, but he didn't fill it out. And that's what the judge went by, instead of the complaint.
You were asked about your experience initially when Ms. Amos started questioning you. The experience from 2018 to 2022. Can you tell us, was your experience, did your experience as a lawyer trying cases start in 2018 after you were barred?
I'm gonna object. That's leading to.
Rules.
I'm sorry, ask the question again.
You were questioned about your experience, and you were limited between the time frame of June 2018 to 2022 when the appeals were filed. I'm asking, did you have any legal experience prior to 2018?
I mean, yeah, it depends how you define legal experience, because I was in law school. I guess that would be legal experience, but I mean, I had the case with, the prior case, the civil case, where we got the verdict.
It was right at the beginning of the case. It wasn't way after the case had begun.
I mean, I guess I was self-taught before I was a lawyer. I got more experience than my bar number would probably suggest. But I was doing a lot, like, actually.
And in that prior experience, did you have the opportunity to come across the city's law department?
I'm sorry, I didn't hear that question.
In that prior experience, had you ever come across or have any legal cases with the city's law department?
Yeah, yes, I did. These cases all concern the law department and Hubbard. So it started back, this is the saga. It's not just I met Hubbard the first time at this. I dealt with them before. Extensively, actually.
The case management conference was held later, but the paperwork, everything he had to turn in for the case management conference, he had 5 days at the beginning of the case to turn it in. He did turn it in a little late. Not like months late though. But this was way at the beginning that he didn't even have discovery yet.
Especially with that civil rights case. That was a saga.
Last question for this. With that, you said that experience with the city's law department was the start of, let me say this, just briefly explain how the city's law department is the foundation for these cases and these allegations that there's a bias, appearance of bias.
I mean, how it's a long history.
Just concisely.
I think this is the prior case is like the but-for cause, I think, of these proceedings, because I think it's just retaliation. And it's not, and I'm not saying that subjectively, I'm saying that objectively. Out of all the matters I dealt with, contract matters, real estate matters, I'm only here for disagreeing with the city. And as I'm going to testify, you're going to see, it seems like certain judges, not all judges, I wouldn't dare disparage all judges, I'm not saying that, but I think there's some selectivity in how I'm being treated versus how they're being treated when misconduct is on their behalf. And I think there some certain persons may be just, pushing the scales of justice a little bit, as we're going to testify through my defense.
As far as you know,
The plaintiff,
was there ever, or I want to say, did you have a good faith basis for filing everything you filed in this case?
I had an objective, good faith basis based on facts and information that I had and that was reasonable. And to be sure, you're talking about, like, you said everything, so that includes the motions to recuse as well, right?
Yeah.
Yeah, that's why I was trying to preserve the issues for review. If we were going to argue the motions for recuse on appeal, because I already knew if this case was going to appeal once the judge made that decision, that the cases aren't worth a certain amount without a hearing or evidence, because I already knew I wanted to preserve everything. I already knew what was going to happen. And everything was based on what was objective. And I specifically said the appearance because I don't know actually what the judge like knew in his mind. I just know objectively based on what I had. And then I know the situation is unusual, especially with the prior case. So that's definitely a monkey wrench. And that's what I had. Everything was based objectively on what I knew at the time.
Nothing further.
Sounds.
Mr. Bell, you said that you testified in response to your counsel's question. That
Right, and he didn't have any of that yet. They didn't go through any of. So they had I can't remember something about a knife being pulled out in the store. They didn't get injured. They didn't get stabbed with a knife. All right. But psychologically, they had trauma, and he wrote that in there. Psychologically, they had trauma. Well, they didn't go to any therapist, anything. They didn't do any of that yet. It was so early in the case. They didn't do that. They didn't have that. He didn't know if they were going to have that. So he didn't answer. Who knows? I don't even know now if they went to a therapist and they had medical expenses for that. No idea. He probably knew later in the case, but he didn't know that. He didn't have any of that information if they were gonna seek medical help or not. They pulled out a knife on him. He did not get stabbed or shot or anything like that, but they had psychological trauma because of it.
it was retaliation against you, correct?
I think these proceedings, to me, I think they appear to be selective, yes.
So I'm not talking about these proceedings. I'm talking about what occurred in the three matters. What matters? I'm talking about the Murphy matter, the Miller matter, or the Murphy, the Miller, or the Myers matter. What of those three cases were retaliation about the rulings that occurred?
The arbitration order, in my opinion, I think was clear retaliation.
Against you personally?
Yes, against me and against Mr. Payton. I guess every case I brought up pretty much. I think Andrew saw my name on it and he made a subjective ruling and he just was gonna not respect my client's rights. That's what subjectively, that's what I believe, but my subjective opinion was based on the judge's objective conduct by making a determination on these cases without anything based solely on what Mr. Hubbard said. That was the part to me that like, whoa, that pushed me back a little bit. And they have separate injuries. And if you read the complaint, they got separate injuries. It's different stuff. In Rubino, I didn't file any motions to recuse or anything with Rubino. I just thought his opinions were exceptionally biased. And you didn't discuss that, but we'll discuss that and you'll see why I objectively think so. And it appears that like when there's a disparity in treatment, it's like why am I being treated like this?
Philadelphia.
But they could commit misconduct or make a false statement or produce a witness that never existed. But the night of motion for summary judgment, we got new evidence and I'm always blamed for everything.
So you believe you were wronged in all these cases by the judges?
I think there's some disparate treatment.
And again, when you initially filed these cases in 2019, 2020, you had already been, I understand what you testified before, that you had legal experience before this. But you would agree in order to practice law in front of a federal court or the court of common pleas, you need to be licensed in that jurisdiction. You would agree with that, correct?
Of course.
Okay. So your contact with these judges, let's say Judge Rebrano, in 2020 when you filed it, that was your first contact with Judge Rebrano, correct?
Yes, Rebrino, yeah.
Okay.
Correct.
Okay. And besides the one in-person interaction with Judge Anders, you didn't have extensive contact with Judge Anders after you were admitted into the bar, in the Pennsylvania bar, to practice law, correct? And I'm not talking, I understand what you said with the Jarvis man. I understand that. I'm talking about after you were admitted to practice law.
And the question was, I'm sorry, it was
They did bring up yesterday, which doesn't make sense to me a little bit. I don't know if you heard it. I think I was picking up Anthony. So he had a case. It was that federal case. And there was another co-counsel with him. And that other co-counsel had to leave for a while because of personal things. He wouldn't have enough time. And there was another counsel that helped on that case. And those two never actually filed appearances. But they did file for attorney costs. They $50,000. They filed for money to be awarded for lawyers' fees. He was the only one. He was listed as head counsel. He was with the case the whole time from beginning to end. So he filed for attorney fees. That made sense. These other two lawyers also filed for attorney's fees. And this court was questioning him yesterday about why the other two lawyers who never made an appearance on this case, or the one guy made an appearance and then withdrew, and then like a year later filed a motion, which I guess in federal court automatically means you're appeared. They were asking him while these other two lawyers were filing for court costs, for attorney fees, when they weren't, they weren't appeared on this case. So, but that doesn't have anything to do with him. He was lead counsel. He stayed with the case the whole time, and he should file for attorney's fees. 100%. But because those other two did, that's wrapped up in this complaint the judge made about him. And I don't know why. Hopefully we find out more about that.
kind of long. I'm sorry.
The question is, because I want to clarify that I understand your stance on Jarvis. I understand that.
He does not believe he messed up at all. He's going to die in this hill. He fully believes there was racism going on and discrimination and retaliation. And he says he can prove it. And if he can, good, because corruption in the court system has no place.
But what I'm talking about is after you were admitted into the bar, where you were allowed to practice law. Besides that one interaction with Judge Anders, you did not have extensive contact with Judge Anders when these two cases were filed.
That is accurate.
Okay, thank you. In regards to Judge Wallace, you would agree that besides the Miller and Myers matters, prior to those, you did not have extensive contact, if any, with Judge Wallace.
Before or after? I don't even know the lady. I mean, I've seen her one time at an oral argument when the cases were combined. I don't know her.
Thank you. I have no other questions.
Okay. And do you have any other witnesses?
I have no other witnesses.
Would you move in the admission of any?
So at this time, I would like to move into admission. Do you want me to list all the exhibits, or can I do one through?
First, what's the range that you're offering here?
What's the range?
Yeah.
ODC 1 through ODC 57.
It's all.
All of them.
All right.
Yes, all of them.
Mr. Duckett, do you have an objection?
No objection.
Okay, so those will be admitted. Anything else, Ms. Adams?
Other than that, I don't have anything else to offer into evidence.
Okay. Let's take a 10-minute break, and then when we come back, Mr. Duckett, you can proceed with your case.
And that's it for today. We will not return shortly. We will return in 22 hours. Thanks for coming out today, guys. I appreciate it. I'll see you all again real soon. Behave, okay? Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so